The nature of the cases the OSP handles are extraordinarily complex, and it is acknowledged globally that corruption cases are among the most difficult to prove. These cases cannot be judged simply by how swiftly an arrest is announced or prosecution is commenced and concluded. They require immense time, painstaking mining of credible information, forensic analysis, adequate resources, and cooperation across jurisdictions. And so, on 6 August 2026, a federal jury in Brooklyn, New York, convicted Asante Kweku Berko, a dual citizen of Ghana and the United States, and former managing director of Temaoy Refinery, and former executive director in the investment banking division of the US-based Goldman Sachs Group, of conspiring to pay and pay more than $1 million in bribes between 2014 and 2015 to multiple Ghanaian officials in connection with the development and financing of a 370 megawatt fuel oil plant in Tema, Ghana, under a deal between the Republic of Ghana and AKSA Energy Üretim, a Turkish energy company and a Goldman Sachs client. The OSP provided investigation and evidentiary assistance to the Federal Bureau of Investigation, FBI, of the United States through Ghana's established mutual legal assistance framework. The involvement of the OSP has been acknowledged by the United States Department of Justice, DOJ, as providing significant assistance to the prosecution. Even with this, people say, we claim it is always the OSP. The conviction underscores the importance of international cooperation in the investigation and prosecution of complex corrupt acts spanning multiple jurisdictions. Predictably, the outcome of the trial of Berko in the United States ignited immense public interest and discourse on the domestic dimension of the investigation in Ghana. We wish to state clearly that the OSP's work on the matter did not end with the assistance provided to the authorities in the United States. We have been actively and carefully investigating the Ghanaian dimension. I say carefully because it must always be borne in mind that a conviction of a person in a foreign jurisdiction does not, of itself and without more, establish criminal liability under Ghanaian law or justify the immediate prosecution of other persons in Ghana connected with the underlying conduct. Each person's act must be assessed under Ghanaian law, using lawfully obtained evidence capable of supporting a prosecution here. The nature of the evidence and the applicable law determine whether prosecution should be commenced in Ghana or otherwise. That is to say, the conviction of Asante Kweku Berko in the United States does not provide automatic basis for the prosecution of identified persons who acted with him under Ghanaian law. The circumstances of the case are such that the actions of Berko may not necessarily establish culpability in other persons under Ghanaian law. The OSP will not prosecute a person solely on the basis that a person's name appears in proceedings conducted in another country. Equally, the OSP will not hesitate to prosecute such persons where the evidence establishes a proper basis for so proceeding. As I stated earlier, we have been carefully investigating the Ghana dimension, and our public silence has not meant inaction. Our involvement with the case and the evidence so far enable us to identify the following as the main persons of interest in this case. 1, Kwabena Donko, who was at all times the Minister of Power. 2, Francis Walkson Kwesi Jata, at all times the technical advisor to the Minister of Power. 3, Solomon Ajete Sowa, at all times a deputy director at the Ministry of Power. Lyndon George Nisor Metal, at all times a director at Tricop Group Limited. And Bafo Ankuma Brobe, at all times an employee at Tricop Group Limited. These are our persons, our main persons of interest for the time being. Other persons of interest include some present and former employees of Volta River Authority, Ghana Great Company Limited, Electricity Company of Ghana, Public Utilities and Regulatory Commission, and some staff of the entity formerly known as the Ministry of Power. Please bear in mind and this point should be strongly emphasized, that the person of interest is not necessarily a suspect. The two categories, person of interest and suspect, are distinct investigative classifications and should not be treated as interchangeable. Then again, identification in either category does not constitute criminal culpability or conviction until guilt is proved beyond reasonable doubt to the satisfaction of a court of competent jurisdiction. So, we should be circumspect as to how we report this announcement and how we treat the named persons of interest.